The number you have reached, 911, has been changed to a non-published number.
Good day, ladies and gentlemen. I'm Ken Lammers. Welcome to Cltv. Today we're going to discuss two topics. First is going to be a quick section on tech for lawyers, and then we're going to talk about prosecutorial immunity. And with that, ladies and gentlemen, let's start our show. So our first topic is going to be tech for lawyers. And this will probably be more help for those of you who are defense attorneys driving around long distances from court to court. But you know, even me, I drive a half an hour to work and half an hour from every day, at least as long as I can afford the gas. I may end up getting stuck at work eventually if it keeps going up. But, you know, and on the odd occasion when I do a special prosecution in another county, I may drive 2 or 3 hours one way around here. So, you know, there is some call for something to do or something to entertain you while you're driving. And what I'm going to review today is Audible.com. Now, Audible.com is something that's been around for a little bit. It's really kind of caught on. All the tech shows really started pushing it for a while there, which was kind of strange for tech podcasts to be pushing it, as it was pretty much a competitor for them. But they did, and it's become probably the monster in the area. And what Audible.com does is it's Audible books, which are surprisingly addictive. And you know, as you're driving, it's really interesting how well you can follow an Audible book while you're driving from point A to point B. Now, Audible.com is well, here's the site right here. Audible's, you know, it's got a number of selections. You see down the one side, there's, you know, sci-fi, adventure, all this sorts of things. And you sign on, you get in, and you choose a book. Now, the books are a little bit on the expensive side, something up to $20, although some are cheaper, depending on what special deals you caught. And it may have been by dint of the way I joined, but I get a free book every month. Which is enough to sucker me back in, let me tell you. And here's what I'm going to show you. Here's where the download software you download, and it's got your library. Now, this isn't my entire library. There's some that I bought that are still online, or that I'm not keeping on my computer anymore. But what you'll see here is, you know, there's 3 science fiction books, each cut into Part A and Part B, about 9 hours apiece. You know, and then one religious book, or actually it was a philosophy book on St. Thomas Aquinas. And then, of course, there's Ian Fleming, a Bond book, which is actually pretty good. Now, and here it is where it's connected to my my Creative Zen I'm sorry, you know, the Zen's competitor to the classic iPod, which was, in my opinion, a better product, but of course never really got the market the way Apple did. And it shows you how my Zen is hooked up and how much space is left and how much space is taken. And you know, these are really kind of good books. Now, I'm a science fiction guy, well, I should say space opera guy. These kind of things engage my mind a little bit. So I enjoy listening to this back and forth. And I'm going to tell you, but you can find a fair number of other things on there. I'm going to evaluate this with ups, downs, and cautions. The ups. There's a pretty big library here. And they're done different ways. Some of them are done more as audio plays. Others are done just simply as one person. The majority of them are done as one person reading the entire book. Downs. The search on the page isn't as good as I would like it to be. It can be a little bit rough. And it really only gives you like three blocks of 3 books apiece to look at. And otherwise you have to kind of search around and find what you're looking for through the search function. It's a little bit awkward, but you can get what you're looking for. Now, the one thing I was kind of disappointed in, it's not an overly huge library. There's a lot of stuff there. Cautions. The biggest caution I've got for anybody that's going to Audible.com is that you should be listen to a clip. Listen to the clip and see if the person reading it is distracting, or if it's being performed as a play format, if it's distracting. My experience in this, and I'll tell you, this is the, I went and was looking through, like I said, for books by St. Augustine or by St. Thomas Aquinas, and didn't actually find original documents. What I found was, great philosophers series. So I download the St. Thomas Aquinas and the Great Philosopher series. And it's read by Charlton Heston. Okay, that's distracting. And he's reading it like a great dramatic act, which is again distracting. That's my suggestion to y'all, the tech tip of the week, and well, go check it out. I'm sure y'all find something you're interested in there. So, the main topic today is going to be about prosecutorial immunity and tangentially prosecutorial ethics. Now, this all started with Gideon posting on the 13th about how removing prosecutorial immunity, and how there's a case that might go before the Supreme Court about removing the absolute immunity of prosecutors. I think it comes out of California. Gideon, well, the case is actually accepted by the Supreme Court the next day. This is then taken on by simple justice, who asked whether prosecutors are worthy of total immunity, and who tells us that prosecutors are scared of being held accountable. And then we go on back to Gideon, who talks about how ethical violations, a reluctance report, and how people don't report prosecutors, and prosecutors don't get in trouble even when Court of Appeals finds that there has been some sort of prosecutorial misconduct. And then we go off to Seeking Justice, where Tom tells us, he goes on about how, look, Brady violations, that's if it's prosecutor's fault, it isn't the prosecutor's fault all that often, or isn't always the prosecutor's fault. A position that when I was a defense attorney and prosecutors seemed more omniscient and omnipotent, I might not have agreed with so much, but now that I'm working in a prosecutor's office and seeing how you've got 60, 80, 100, 150 cases, usually more like 100, and then you've got an officer or detective or investigator who's working with a similar caseload of his own and trying to get things done, how things can potentially slip through the cracks. That's assuming no bad faith. Obviously if there's bad faith, it's different. But so I'm not going to discuss all these points, all these posts. I'm going to talk a little bit about ethics, and then I'm going to move on to what Virginia says about immunity, sovereign immunity. And I commend all these posts to you, and we'll let you go read them yourselves. First of all, let's talk about the ethics, prosecutorial ethics. Now, primary responsibility of a prosecutor is to make sure there's probable cause. In Virginia, we're buffered somewhat in that before a case hits my desk, it has either gone through a magistrate who has certified probable cause from either a citizen complaint or an officer's complaint, or it goes through a grand jury which has certified probable cause. Now, that takes care of the ethics of it, unless something comes up afterwards, which I maliciously suppress, or I have falsified evidence prior that went to the grand jury or to the magistrate. So, assuming no bad faith, of course bad faith is always problematic, but assuming no bad faith, a prosecutor in Virginia is insulated ethically. So what are the legal obligations of a prosecutor in Virginia? Well, or what are our legal liabilities as to being sued. There's sovereign immunity, and as much as people don't like sovereign immunity as a doctrine that rose out of the divine right of kings, and you couldn't sue someone who had been given his power by God himself, there is a reason for the doctrine of sovereign immunity beyond just that. It's the continuing function of the government. Now, if it hadn't come from that rationale and then moved into modern day, it would have come from another rationale. The best explanation I think I've seen for it comes from City of Chesapeake and Cunningham, which is a 2004 Supreme Court of Virginia case. This is a good case overall if you want to look and see what sovereign immunity is about in Virginia, although it's generally about municipalities' sovereign immunities. I'm going to read this, and we'll read a couple things because they're a little bit long, but and I want to make sure you get them right. Sovereign immunity is a rule of social policy which protects the state from burdensome interference with the performance of its governmental functions and preserves its control over state funds, property, and instrumentalities. In other words, if the government's doing its job, it should be, protected from, if there's a 5-4 vote in the city council, the decision of the city council should be protected from suit in court. Because it has made that political decision for the good of the people. Now, in municipalities, it's cut into governmental functions and proprietary functions. Governmental functions are, powers and duties for the public welfare. Proprietary functions are for the benefit of the municipality. The municipality in Virginia can be the county or the independent city. I guess the independent town as well, or the town as well. Now, the opinion admits to us that it's difficult to figure out exactly what's governmental proprietary, and having looked at the examples that they give in a couple or three opinions, I'd say it's probably one of those things where until a court tells you where you're at, you probably don't know, unless it's really clear-cut in a prior case. But the cases seem to be pretty strong, or actually this case actually seems to lay police powers in the governmental section of municipalities. So police powers being what they are, powers that lay in the Commonwealth Attorney's Office, Sheriff's Department, and Police Department. I suspect that there is sovereign immunity there for the Commonwealth Attorneys. But there are more specific cases that we probably need to go through. I couldn't find any specific cases about Commonwealth attorneys or assistant or deputy Commonwealth attorneys being sued in Virginia. So I did a search for constitutional officers, which is what a Commonwealth attorney is in Virginia. There's certain officers laid out for each municipality, city, or county that are in the Constitution of Virginia, and among them are the Commonwealth attorney. And in the case here, it was the clerk of court. Clerk of court is a constitutional officer who's elected, I think, every 8 years, as opposed to the others who are elected every 4. And this is the first Bank of Virginia Colonial against Baker, and it's from the Virginia Supreme Court in 1983. And the clerk of court tries to say there was the facts of the case are something along the lines of, an assistant clerk somewhere misfiled something having to do with property, and the people, the bank and some others relied upon what they were able to find, and later on got hit for a loss of thousands of dollars, and they sue the clerk of court. The clerk of court tries to apply immunity, sovereign immunity, and tries to say that its respondeat superior doesn't apply to him because the assistant clerk did it. The Virginia Supreme Court doesn't buy that. Says that the clerk of court may be entitled to claim the protection of the doctrine of sovereign immunity for wrongs committed by him in the exercise of his discretionary duties in his office. So if it's a decision made by the clerk of court, he's clear, free and clear. However, they find no logic in the rule that exempts him from the doctrine of respondeat superior, whether the wrong committed by his deputy is discretionary or ministerial in character. This decision doesn't make a whole lot of sense to me. It basically seems to say that if it's a decision made by the clerk of court, well, he's absolutely immune. But if it's a decision made by one of his lower officers, which, you know, let's face it, if we're talking about a big county or big city, you know, there's going to be a number of lower officers that are going to have to make decisions for the clerk of court. You know, if that lower officer makes a decision or mistake or whatever, the clerk of court is responsible for that. You could try to apply this across the Commonwealth Attorney. I don't think it's a good fit, actually, because it's a different sort of thing. You know, we're talking about civil property, keeping of records for the entire county or city, and misplacement of records causing thousands of dollars worth of damages. It doesn't really fit well with Commonwealth Attorneys' offices. But, you know, if you really stretch it, you can get it there. And it doesn't seem to, you know, make a whole lot of sense, actually. More to the point in Commonwealth Attorneys' offices would be, I think, the malicious prosecution cases. And there have been malicious prosecution cases since that 1983 case, which seem to be more fitting for Commonwealth attorneys. Now, malicious prosecutions, I'm sure this is the same in any number of states, the malicious prosecution civil cases are disfavored. And all the cases say that. The case I'm talking about here specifically is Tomlin against McKenzie, which comes from Virginia Supreme Court, 1996. Now, they're talking, and this is not a Commonwealth attorney, this is actually somebody working in, I think, social services or some such office, who tried to claim, you know, I have the same immunities as a Commonwealth attorney, which gets shot down. But, and well, I think this is that one. It may have been actually a police officer case too, but there were 2 or 3 cases along these lines, social service officers and police officers primarily, and the court shoots them down mostly. And here's what the court says, the standard is, where sovereign immunity is claimed by an agent of the state rather than by the state as an entity, it will not be extended to acts which constitute a wanton and intentional deviation from the duties the agent has been assigned to undertake. So, it is, you know, I'm an agent of the Commonwealth Attorney's office. If I stay within the boundaries of my office, you know, within the boundaries of my duties, sovereign immunity covers me. If I go outside of them, doing such things as I talked about before, falsifying evidence to give to the grand jury, or hiding evidence after the grand jury has met so that the defense counsel doesn't know that his client's actually innocent, well then, you know, obviously I've gone outside the bounds of my office, and I could be liable for prosecution, or liable for civil prosecution. It'd have to be a stretch, though. Now, we look at these cases, and by the way, in this case here, Tomlin, you know, I think my boss, the Commonwealth Attorney, who is the government, is free and clear. He's just not going to get tagged because he's the government. I'm an agent of the government. If I act improperly, you know, well, I can get BSOL. Now, the case out of California, the one the Supreme Court has accepted. Now, I looked at I didn't go back and read the petitions or anything like that, and you know, I'm sure there'll be a million amicus curiae and thousands of dead trees wasted out there by the time it's all over. But I looked at a couple of news articles, and one from the AHN and one from the New York Sun. And here's what they primarily say, what they say is going on here. You know, a guy spends 25 years in prison and eventually has his conviction thrown out and is out of prison. Now, his conviction was primarily based upon an informant who said that there was a jailhouse confession that he heard, and then testified when asked on cross by defense counsel that no, he'd never informed for the prosecutors before, which is a lie. Apparently he'd been a frequent informer for police and prosecutors, but there was no process for keeping track of who was informing, and therefore the prosecutor's office, the prosecutor in the case, didn't know, didn't turn it over, and defense counsel wasn't able to impeach properly, and the conviction went through. Now, according to the New York Sun, the actual issue in the case that's being put forth is they're suing, and sovereign immunity has been pled, but they're saying no. Sovereign immunity should apply to the prosecutor who's in the courtroom. It shouldn't apply to the managers in the prosecutor's office, the primary Commonwealth attorney, prosecutor, I guess in California it's probably district attorney, should not have sovereign immunity for management decisions. Okay, the problem here is that flips things on its head, on their heads. The cases I've read, at least per Virginia case law, that would flip things on their head, where me as an agent of the Commonwealth attorney, if I make discretionary decisions, or if I do something improper, then I'm liable. But my boss isn't if he makes decisions. And in this case, the decision made, or actually never made apparently, was keeping track of informants. There was no system for keeping track of informants, and that's a decision made by the head prosecutor. He never instituted something to do that, and therefore there was no knowledge of this informant having informed previously, and the conviction took place. Now, and there may have been more to it than just that, but basically all the articles are talking about is the primary issue is the fact that the informant lied on the stand about whether he'd informed before. I think it's pretty clear, that the head big guy, the head prosecutor, in using his discretionary powers in not setting up, something to keep track of all these informants, is not liable. That's an executive level decision made in the discretion of the constitutional officer, or whatever they're called in California. The primary officer in the office makes that discretionary decision. That discretionary decision is covered, by it's a police power decision. It is a decision made by the top guy in the office. Sovereign immunity all around, and I think that's pretty clear from the cases I've read. Now, if the decision, if it had come down and it had been the line prosecutor who'd said, "Oh yeah, I know Bob has testified 17 times or turned over evidence 17 times," and he didn't tell that to the defense attorney, then the line prosecutor would be the person who doesn't get the sovereign immunity protections. So what they're trying to do when they go to the Supreme Court is flip it 180 degrees so that they can get their prosecution in. Is that a good thing? I don't know that it is. I think that purposeful bad acts, yes. There shouldn't be sovereign immunity for purposeful bad acts. I'm not sure, sovereign immunity for even the bigwig for purposeful bad acts probably isn't appropriate, but I think it would probably stand. But the lower level agents, the line prosecutors, prosecutorial immunity or sovereign immunity for purposeful bad acts shouldn't be there. Okay, having said that, then when we get to the discretionary areas, management decisions, I don't think that it really makes sense. I mean, 20/20 hindsight, you can always, in every single office, 20/20 hindsight, you can find something wrong. It's there things have gone wrong, things will go wrong. There is no such thing as a perfect world. But, you know, suing this person for doing his job in a particular manner when there was no foreseen problem at the time isn't really, well, even foreseen problem or not foreseen problem, when he's acting in his discretion as the primary officer of a, you know, a sovereign office, a sovereign part of the government, doesn't make a whole lot of sense. Purposeful bad acts, yes. Discretionary actions in the management of an office, no. It doesn't make sense to sue on those grounds. You really, I mean, it's emotionally satisfying. It's emotionally satisfying to look over and say, you are the reason that I'm in jail for 25 years. Because you made a management decision which eventually ended up with me in prison. Well, you know, you, being the chief prosecutor, is going to make management decisions all over the place, all the time, with limited resources as to what he's going to do, whether he's going to do X or Y or Z, and the ability to foresee something like this, you know, 25 years ago, you know, who knows how, 25 years ago, when there really weren't as many, you know, computers and all these sorts of things that you could use to keep up, I don't know it's there. And I've got to say that while I think that the person here that went to prison, you know, assuming he's not guilty, probably should get some recompense, and I can't say it, should get some money from the government, you know. I don't think it should be, you know, particularly liable to the person who was the Commonwealth Attorney, you know. And in a legal grounds, I don't think it's there. So that's my take on it, ladies and gentlemen. I don't think that their case on sovereign immunity, assuming that sovereign immunity is fairly uniform around the country, which I don't know, but assuming it's fairly uniform around the country, a discretionary management act on the part of the primary prosecutor, the elected official, appointed official, I don't know how it's done there, is subject to, you know, prosecutorial immunity, sovereign immunity. He should not be prosecuted for that. Short of a purposeful bad act on the part of a line prosecutor, you know, the prosecutor involved in the case, and you might even, in that case, assuming the prosecutor, the primary prosecutor, the elected guy, you know, does this as administration and this is him in the prosecuting somebody, assuming he actually went to court to prosecute anybody, you might say that in this function where he's prosecuting someone, he's not acting in his sovereign immunity, prosecutorial immunity position. He's a line prosecutor here, and there he can be found responsible. But in discretionary administrative decisions, I don't think he should be. That's the way I see it, and I'm sure that I'll get plenty of feedback on this. Look forward to it. And ladies and gentlemen, that's it for this week. Next week, I'll see what interesting topics y'all have put in my mind to talk about then. Have a good week now.